Hi, this is Shawn Palmer with the Palmer Law Firm, and today we're going to ask a very important question, and an interesting one too. Is getting a divorce a violation of your religious rights? The groundbreaking case of Obergefell versus Hodges, which is a Supreme Court case that linked the right of marriage to a personal right to a protection under the United States Constitution, has sent ripples throughout the family law world. The ramifications of this case will be talked about for many years to come, and just what its limits will be is the topic of family law for just as long. As lawyers, it's our job to take prior cases and apply them to the cases before us, but sometimes that effort stretches things a little bit far. This is the case of Lecuona versus Lecuona out of Travis County. The case was appealed all the way up to the United States Supreme Court, which refused to hear the case. Shawn Hall Lecuona appealed from a final divorce decree that ended her marriage to Mark R. Lecuona. Mark was the petitioner in the original case, and the sole grounds for his divorce upon which he relied, and which the district court subsequently found, was no-fault insupportability grounds. Insupportability is the basis of the no-fault divorce scheme in Texas, and is by far the most common ground for pleadings in Texas divorces. Shawn opposed the divorce on religious grounds and urged that Mark's suit for divorce, and particularly the no-fault insupportability standard on which he relied, unconstitutionally infringed her protected interests in what she viewed as an immutable blood covenant among the couple and the Almighty. In her appeal, Shawn relied on the United States Supreme Court decision of Obergefell versus Hodges, which struck down state prohibitions against same-sex marriage and as a violation of a, quote, right to marry that is a fundamental right inherent in the liberty of the person, end quote, and also protected by due process and equal protection clauses of the federal Constitution. Shawn said that Obergefell translates into a constitutional restriction against Mark using Texas's no-fault divorce law to end marriage. She argued that for her professed religious reasons, she desired to stay in the marriage, and because this was a sincerely held religious belief, Mark cannot divorce her. So the question is, does the state of Texas violate a person's First Amendment freedom of religion if it grants a divorce despite a person's sincere religious belief that marriage is a sacred bond that cannot be broken? No. The court held that Obergefell, whose analysis is rooted in the Supreme Court's view of personal liberty, does not, either directly or by implication, recognize what would effectively be an affirmative constitutional right of one spouse to compel an unwilling other spouse to remain married. The court also points out that to not grant a divorce because of religious grounds of one spouse is a violation of the other spouse's liberty to not hold that belief, and their liberty and state divorce laws would be violated. The court also pointed out that Shawn's theory represents a significant and novel expansion of what was held in Obergefell. People are trying to use Obergefell in many novel ways, but the courts have stated that Obergefell is limited in its scope and doesn't open wide a door to all kinds of novel claims that run contrary to firmly established principles of law. For example, in Pigeon versus Turner, the Texas Supreme Court observed that Obergefell did not address and resolve the issue of whether and to what extent to which the Constitution requires states or cities to provide tax-funded benefits to same-sex couples, or invalidated Texas's Defense of Marriage Acts. They quoted in that case, quote, whatever ramifications Obergefell may have for sexual relations beyond the approval of same-sex marriage itself are unstated at best. In general, the lower courts must use what the higher courts have said at face value and not craft novel extensions to suit a desired outcome. Another example is in Ex parte Morales. In a novel constitutional challenge to Penal Code Section 2112, the appellate court in Austin said that, quote, as an intermediate state appellate court, we must defer to the authoritative pronouncements of higher courts that currently define the scope of constitutional principles we apply here, end quote. Covenant marriages are a perennial bill offering in the Texas state legislature, but they continue to not be passed. And years after years continue with no bill being passed for covenant marriages. Covenant marriages would make it more difficult for married couples to get a divorce by adding additional requirements, waiting times, fees, or other impediments to getting a divorce. Only 3 states so far have adopted covenant marriages, and the data shows that very few residents within those states elect to enter into a covenant marriage. One of the significant reasons why a covenant marriage statute would be difficult to pass is because of the contravening liberty issues cited in the Lecuona case. Specifically, that the state cannot impose any sort of religious conditions on either spouse's right to be married or not to be married. Another aspect to consider are 2 new statutes under the Texas Government Code that went into effect in 2017. These statutes are commonly known as anti-Sharia law, although they were not specifically named as such to avoid them being challenged in court. These also limit the ability of the state to put religious conditions on obtaining a divorce. Sections 22.0041 and 22.022 of the Texas Government Code states that litigants in actions under the Family Code involving a marriage relationship are protected against violations of constitutional rights and public policy in the application of foreign law. Foreign law, as the proponents of these statutes have attempted to make sure do not apply in Texas courts, was the religious-based domestic laws of Muslim countries, or Sharia law. Could these new statutes be used to further prevent religious conditions being imposed in getting a divorce? I think that's an interesting thought. Anyway, thanks for tuning in. If you have any questions about your own divorce or family law matter, please visit our website at www.thepalmerlawfirm.com. I'm Shawn Palmer with the Palmer Law Firm, where we can't protect your heart, but we can protect your rights.